everyone. I'll introduce myself and talk a little bit about what I'm going to talk about. So my name is Hannah Zhao. I'm a staff attorney at the Electronic Frontier Foundation. I actually studied computer science undergrad before I went to law school. And I work at EFF, I work on digital surveillance, privacy issues, and unreliable police technology. So those are my areas. And I'm also a part of the Coders' Rights team, where we consult, help with security researchers, and I'll talk a little bit more about that towards the end of my talk. So as you can see, this talk is called Scraping After HiQ versus LinkedIn. HiQ versus LinkedIn obviously was a big case in the Ninth Circuit. What we're going to focus on is, in the past couple of years, there's been reinterpretations, and the Supreme Court has had a case on the Computer Fraud and Abuse Act, the CFAA. So we're going to talk a little bit about what kind of things, when you do scraping, is going to be more likely to bring you into legal risk, and what kind of things you might do to make sure you're less likely to get sued by other people. So first, I have to give the disclaimer, this is not legal advice. Please don't take it as legal advice. If you have legal questions, please do not ask me right now if something is legal or if you're in trouble. If you come to the EFF booth, we'll give you a card. You can email info@eff.org. I promise you somebody reads all of the emails that get sent there. It'll get referred to the attorneys who work on the specific issue that you're asking about, and then we'll read it. Please also don't, vaguely disguise your scenario now during the Q&A, saying, I have a friend who maybe did this thing. Please don't do that. Again, email us so that we can have attorney-client privilege and nothing you say will be held against you. So law is dynamic. I'm sure we have seen a lot of changes in law, or things that we thought were law or rights, and then they get overturned by courts and they're no longer law or rights. So I'm not going to use really definitive terms like don't do this, this is, this is legal, this is illegal. I'm going to use terms more like this will give you higher risk, this will lower your risk, things like that. And lastly, and somewhat importantly, is that nothing will keep companies from acting like, spoiled little children and trying to harass you or sue you. They can't do they can't go beyond certain lines, they can't cross them. But in terms of filing a case against you, if they really want to put all their resources and time into doing that, and they are paying a lot of money to do that, they can do that. Now, it's unlikely unless they're really, really mad about something or trying to make a point, but that's another reason why your risks will be probably higher than, or like they're always existent, because even if you end up winning on those lawsuits, they might be annoying to deal with. So what we're going to talk about when we actually talk about scraping in this talk specifically is the act of scraping, though web crawling, the gathering the data from websites. And we're not going to be talking about actually publishing that data or using that data in other ways, putting it on your own website or anything else. We're just talking about what if you use these automatic scrapers to get information from websites. The other things that I was talking about that's outside the scope of this talk, those actually entail a lot of other whole pile of legal risks, including copyright, trademark, trade secrets, all that stuff. That's not going to come into play. We're going to talk mostly about CFAA with a mention of some of the state law that comes into play as well. So CFAA, as I mentioned before, the Computer Fraud and Abuse Act. So this was enacted in 1986, expanded in 1984 because President Reagan watched War Games, that movie. And it was originally focused on protecting government computers from hacking, because if you watch War Games, that's what that movie was about. Now, a protected computer is much, much more expansive. It's basically any electronic device that has processing or storage. And I guess we can call this fact fun, but the 2021 TIA 84 Plus calculator is more powerful than most 1986 era computers. So this is how the definition of computers has expanded. So like I said, we're going to touch a little bit on state anti-hacking laws. So in all 50 states, Puerto Rico, and the Virgin Islands, they all have their own computer crime laws. A lot of them are structured similarly to the CFAA, and the type of things that they address would be unauthorized access and also what is called loosely computer trespass. So they borrow this theory of trespass from normal property, you know, like when someone comes onto your property without permission, and they borrow that legal concept and used it in these computer crime laws. Now, EFF, we're really against this. We think it is a really outdated way of thinking about what it means to access a computer. But unfortunately, there are some state laws that have that, and this is part of the reason why these laws are even more restrictive than the CFAA. So this is one of the dangers when you do scraping, even though, you know, obviously EFF's position is that scraping public data is public. You should be able to access it, whether it is through web crawling or whether it is your handwriting on every note of every page that you visit on the internet. All of that should be okay. But because of these other concepts that come into play in the state laws, there can be some risks that you would have if you're in the states that have, you know, more restrictive state laws. So one example of that state is, in fact, California, unfortunately. California, the Penal Code Section 502, it was interpreted in the Friends for Fullerton versus Fullerton case, and this was where the Friends for Fullerton were charged under the California state statute, Section 508, for their scraping of data. And it was a really bad decision. EFF filed some briefs in that, arguing against the implementation of 502, or that interpretation of 502, but you know, unfortunately, it resulted in some restrictions, but that's not going to come into play for the public data that we're talking about here. So, a little while ago, there was a case, Van Buren versus United States. Now, this case was not about scraping at all, but it was the first case that the Supreme Court decided that was about the CFAA. So, if you remember, CFAA passed a while ago. This is the first case the Supreme Court has taken to interpret this law. Took them a really long time to get there, but because of that, it's a very, very important case when we think about, is what you're doing going to get civil or criminal suits against you under the CFAA? So the way that Van Buren talks about it is the CFAA prevents unauthorized access or the kind of access that exceeds authorization. So what does that mean? Well, the Supreme Court said that basically they took a gates up versus gates down approach. So if the gates are up, if it is open, you're allowed to access it, then even if you weren't supposed to, but you could, and you do, then that's not a violation of the CFAA. It might be a violation of other laws. So what that means is, in this case, for example, there was a police officer who was looking in this database for some information that they were selling to other people. It's kind of a complicated thing. But basically, they had access to this database. They were authorized to use this database as a police officer. They weren't authorized to use that database to get this information, to sell it to someone else and do all of that. So the government argued this was a violation of the CFAA, that the way in which he accessed it and the purpose for which he did it was inappropriate, and therefore it was without access. Now, EFF's position is no, it might be a violation of other laws, but under the CFAA, he had authorization. He was authorized to look at this data, and the Supreme Court agreed that he was, in fact, authorized to look at this data, so it wasn't a violation of the CFAA. So what this means is that basically, if you have access to data, so for example, public websites, anyone can visit public websites. Well, almost anyone can visit public websites. You have that ability, therefore you have the authorization to visit that website. Therefore, when you take information from that website, that is okay. Then, this is a way of thinking about the law that EFF agrees with, that we liked, but there's this issue where there is footnote 8, which suggests that there can be a withdrawal of authorization. So when we're talking about scraping, if you're authorized to access the data, so like a public website, you can scrape it. But what does it mean in the context of a website to withdraw authorization? The Supreme Court did not explain. Footnote 8 confounds a lot of lawyers. It's probably gonna, be able to fund a lot of lawyers' salaries for the next couple of years as this is litigated out exactly where the confines of this withdrawing access means, but that is one of the things that you would have to worry about. So what do we mean when we say withdraw authorization? How can you withdraw authorization from a public website that you're scraping? So, and in comes HiQ versus LinkedIn. So HiQ versus LinkedIn began before the Supreme Court took up Van Buren, but it also continued after Van Buren. So HiQ was basically a data analytics company that was scraping LinkedIn website for information so that they could use it in their data analytics and sell it to businesses. LinkedIn decided they had been letting HiQ do this, but then decided they basically wanted to make the same kind of product. They're like, we have all this info, why don't we just make money by building data analytics off of it? So then it sent a cease and desist letter. So the question is, when you are scraping public information, but you get a cease and desist letter, does that withdraw the authorization that you originally had? EFF's position is obviously, as I mentioned before, no, because this is a public website. You can't, the gates are up for everyone, so if the gates are not down, so therefore this cannot be a violation of the CFAA. But LinkedIn argued this, and then the Ninth Circuit actually, prior to Van Buren coming out from the Supreme Court, agreed with EFF, said this is not a violation of the CFAA. But after Van Buren was decided, HiQ was also up on appeal at the Supreme Court, and the Supreme Court said, hey, we just decided this case in Van Buren. We're gonna put this back in the Ninth Circuit. You re-decide it based on what we said in Van Buren. So the Ninth Circuit looked at it again in HiQ 2. They said that Van Buren's gates up or down inquiry, which only applies when authorization is required. And as I said before, if it is public data, then authorization is not required. So that means that Van Buren, basically, its decisions really reinforced what it had originally decided. So it again said that scraping information from public websites is not a violation of the CFAA. And we're really, really happy about that, because if you think about data, there's basically 3 categories, right? There is a category where you only get access to it through credentials, so you have to, log in and things like that. Then there is there are other ones where there's password protected, and then there are ones where authorization is given, but there's a third category, which is what is open to the general public. So it's not about did you have authorization to log in, it's that you don't need a login at all. So what the Ninth Circuit they're still litigating this, in fact, but what they said at the end of last year was that HiQ is likely to win on the scraping violating CFAA issue, but because it was scraping public profiles. Now, there's an issue because HiQ ended up hiring Turks to so basically to build fake accounts on LinkedIn and scrape the data that you would only get after you had an account with LinkedIn. And that is a different issue that did entail higher risk. So the court said that was a violation of the user agreement. So what you can see here is the more authorization and the more steps you need to take to get that data, the more closed off it is, the higher the legal risk that you're taking on when you decide to scrape that. So public information that is just on the website, totally okay. But then if you get down to you have to log in to access that information, that is a little bit iffier. And especially so if to log in and to create that account, you had to click, one of those, whenever you create the account, you have to click, I agree to these terms or whatever. Often in those terms, there will be prohibitions of scraping data. And while LinkedIn had argued that prevented HiQ from scraping the data, even of its public profiles, it was scraping it, but it was public profile, but they said they still created these accounts. They still clicked, I agree, for these contract terms, these user agreements. But the Ninth Circuit said that didn't apply to the public stuff, but to the private stuff it did. And also LinkedIn prohibits creating fake accounts prohibits fake accounts in its user agreement. So in creating this account, in order to do scraping, it violated the user agreement. So again, when you're scraping data from websites, if it's the kind of website where you needed credentials and there was a user agreement where you clicked, I agree to the terms and conditions to continue, that might entail a lot more risk when you are accessing that data. So, as I said, these Turkers who did the quality assurance while logged into LinkedIn by viewing and confirming the information. The district court granted LinkedIn's motion for summary judgment for this as a breach of contract. So that entails contract law, which is different from the CFAA. The CFAA is civil and criminal. That means LinkedIn could sue HiQ under it, and also, if a prosecutor was really gung-ho about it, could bring criminal charges under the CFAA. That's why the CFAA is really worrisome, because we're not just talking about people losing money or having to pay money, we're talking about possibly jail. So the lingering concerns we have after this huge development leading up to even November of last year is, first, there are no technology barriers for the type of access that you need to create an account for. So in theory, the gates are still up under the Van Buren's idea of gates up versus gates down. The question is these types of, so gates down means, they have technology that is preventing scraping or that is preventing access to the information. So not just requiring authorization, but also not just requiring authorization that anyone can get. Everyone can, can create an account on LinkedIn with real information. So when there are no technology barriers, does that information count as public? Obviously, EFF's position is that it does, but this is unclear. So when you, like I said before, when you do have to create an account, that entails more legal risk. Another thing is that DOJ has a charging policy. So to, tell its prosecutors when they should actually be charging someone with a crime. And that charging policies considers cease and desist letters to revoke authorization. But it's unclear if that's just talking about non-public data or also public data. So when I talk about your risk going up or going down, if you are scraping even public data, if you get a cease and desist letter, now EFF would argue that is no good, but it is not completely clear whether that is no good and whether the Department of Justice considers that to be no good, or does it consider it to be a valid revocation of the authorization that you had. So that definitely, so scraping after you get a cease and desist letter, that increases your legal risk. I mentioned the breach of contract claims, and Also, the trespass claims, which came up in HiQ, but LinkedIn didn't really argue it, so the Ninth Circuit said we're not deciding this. Again, that's the kind of thing that EFF's position is very much against interpreting those types of trespass laws to apply to computers and accessing computer information, but this is also kind of a gray area. So, what should you do when you actually come across these types of issues? Well, the EFF has a Coders' Rights Project. I'm part of it. It is a team, a subset of our lawyers who provide free counsel to security researchers on legal issues. So perhaps you're conducting some research and you come across something, either you want to disclose bugs or you're like, I'm doing this thing and I'm not sure what my rights are or where I get into really murky territory. And please email us at info@eff.org. Like I said, someone will read it, I promise. And we also have guides up at eff.org/coders. And we are able to consult with the security research community and provide you with some free advice and counseling on your situation. Even if we don't represent you or do anything for you, that conversation will both A, be privileged, and B, we will be able to point you to someone who might be able to help you. So that's the end of the talk. Do we have questions? Yes.
Thirdly, how should one interpret anti-DDoS measures?
The what measures?
Sorry. So, for example, sometimes it looks like proof that we're doing capture. Is capture in front of public information withdrawing that?
So that is a really good question. Yes, is adding one of those CAPTCHAs to make sure that it is a human and not some code trying to access the data. It does that. So that, in terms of revoking authorization, it does not, but it does give them, yes, for the rest of it. So in of itself, the existence of that would not necessarily suggest that there's a revocation of authorization and therefore shouldn't change the legal risk that you're taking on, whether that exists. But if you have signed a user agreement and the user agreement in there says things like you cannot use automatic sweepers, this might be something that comes into play in the breach of contract claims. Yeah.
Hi there. Can terms of service deny authorization to access a public website?
So some of them do say that. It is, based on the law right now, it is probably unlikely that it can be used for that. There may be issues with contractual. Sorry, there may be issues with like I said, user agreement, like the EULA issues that come into play, the breach of contract claims, but it looks right now that is not very effective. Now, again, this can be wrong. Like I said, there will be a lot of litigation about what footnote 8 meant, and that is one of the worries. Although the direct opinion of Van Buren actually suggests that that's not effective, that having that in the TOS is not going to be effective. Yeah. So his question was, what if the terms of service includes that you can't scrape data from the public website? So my answer was, if you clicked the I agree thing, there might be contract issues, but it looks like from Van Buren that should not be a problem, that you should still be able to scrape it even though the terms of service says no. Any other questions?
We have time for one more question.
Has there been any legal cases or research into, like, for instance, where the New York Times, they allow the Google crawler to see all of their articles, and there's websites that'll go and grab them for you.
Yeah, so I'm not aware of the legal cases of that, but there is, both in the DOJ charging policy and in Van Buren, there's some suggestion that essentially the type of frame that New York Times has is there is no authorization, but we will grant authorization to specific parties, so like for Google crawlers to get it. So it's okay for Google to, but it is not okay for someone that the New York Times didn't say it's okay to, because they have decided that their information is going to be behind a paywall. Okay.
Do you want to do one more? Okay. It's time for one more. This is short.
Describing where the case was against the person who had done the scraping. How does that match in with what you're describing?
I'm sorry, can you repeat the question? Sorry, I didn't hear.
Well, haven't there been some cases that were decided against the person who did the scraping? I'm assuming that those preceded these decisions, so they're in contradiction with each other.
Yeah. So, for example, Friends versus Fullerton, they found them. So, Friends for Fullerton was found to be in violation. So, the cases that had interpreted the CFA in a different way from Van Buren, those cases are overturned and they're not good anymore. But if it is under a state law, like the Friends for Fullerton case, where it's about the California state law, those are problematic, and those are something you would have to worry about. So yes, where you're doing the scraping and where that information is, that also changes how much legal risk you have. So, all right.
Thank you very much.
Thank you.
Okay.